Supreme Court of the United States, for better or worse, has recognized exotic dancing as being an activity that's protected under the First Amendment of the U.S. Constitution. As such, that activity can't be banned outright, but it can be regulated in a way that doesn't amount to an effective ban on the regulation. You know, so in other words, just to take a extreme example, a spacing limitation of perhaps 1,500 feet from sexually oriented businesses to residential uses might be enforceable in a place like Detroit, where they have very large blocks of commercial property. On the other hand, it's questionable whether such a regulation would be enforceable in Mecosta Township or another township that has much more limited areas of commercial development. So things like that might act as an effective ban. What the courts will allow are ordinances that address what are some of the so-called secondary effects of sexually oriented businesses. And there have been a lot of materials submitted by some of the neighbors, Mr. Rotman, and some others. There have also been some materials submitted by Mr. Westgate on behalf of General 131, which question some studies and introduce some other information. These ordinances that regulate so-called secondary effects are reviewed by the courts to determine whether they are a total ban or truly are a time, place, and manner regulation. If they are a time, place, and manner regulation, whether they're content-based or content-neutral, and if they serve a substantial governmental interest and allow for alternative means of this type of communication. Now, just a little bit of history. Prior to July or so, the township did have provisions for sexually oriented businesses in its ordinance. But those were very limited. They were in section 3.25 of the ordinance. Essentially what they allowed was for a sexually oriented business to be located in any commercial district anywhere in the township. The limitations were that the business could not be within 500 feet of another residence or certain other protected uses. There was a limitation on signs, and there was a limitation on activities taking place inside the business not being visible outside the business. There were no other restrictions in that ordinance, though. After adoption of the township's master plan in 2010, one of the first tasks that the Planning Commission undertook was to look at the various regulations for the commercial districts, and that brought about an analysis of the way that the ordinance deals with sexually oriented businesses. Now, I've identified, after meeting with a few members of the Planning Commission and Township Board, what appear to be the primary aspects of this ordinance that we want to take a look at and study, reconsider how these were arrived at in the first place, and consider whether they can or should be changed. Now, the first aspect of the Township Ordinance that we want to take a look at is the locations permitted for these types of uses. Unlike the prior ordinance, the new ordinance limits these uses to the Highway Interchange District and the commercial district on 8 Mile Road west of US 131. In conjunction with that, there is a spacing requirement in the ordinance requiring that these businesses be at least 300 feet from residences, churches, schools, playgrounds, other types of uses. And so it might be useful, and I'll ask Gladys if she would please help me, if we could take a look at the township zoning map and the master plan map and illustrate what alternatives are, because part of the process of determining what areas these businesses should be allowed in order to limit the secondary effects, is an analysis of what the options are, where else these businesses might be located, and whether that is a better location or not as good a location. That's what's been suggested in the current ordinance. So if we could, let's just take a look at the zoning maps. Okay, this is the current zoning map. The commercial areas in the township are here, and I guess this would be the Rogers Heights area, correct?
That's all Rogers Heights and through there going into Hayes Road and Albert Drive.
Then there's a commercial area down by the village of Stanwick. Is it?
Also commercial on Northland Drive and 8 Mile, where the A&A Builders is, and Big L Lumber. We have a limited commercial there where the fire department is. When you go west, the other commercial that we have is the BP gas station just west from the 131, then going north to where Stanwood Motorsports is, and just north of there would be the airport, Canes Airport, and coming back across Old State Road, it goes back into Northland Drive and Old State where the Service Master is, and across from there where the trying to think of Les Chuck's construction is across the road there. Curtis Brothers, that's the only other commercial that we have right in that area. The other area that we have would be where Duke's is. I think everyone knows where Duke's construction is there. 205th. Off of 205th. So that's the only commercial that we have in the township itself.
So you can see the areas of the township that are zoned commercial are fairly limited in area. We have the master plan. This is the future land use map of the township, and what this illustrates are the areas that would be proposed for future commercial development in the future as opposed to other types of use. And I think part of the Planning Commission's thought process for putting together the ordinance the way it was is that areas adjacent to what is now the highway commercial district are planned for highway commercial uses in the future. So the plan is that those areas would become commercial. Same thing for the areas on the other side of 8 Mile Road, across from the area that was designated to allow this type of use. Another thing this illustrates is that in some of these commercial districts, there would be other alternatives for location of this type of use. They're adjacent to not only existing commercial businesses, but also to some of the more densely populated areas in the township, up in the Rogers Heights area, and down in the village of Stanwood area. And I think also there are churches in those areas, there are schools down in the Stanwood area. So not only existing zoning was taken into account, but also the likely future areas for places where there would be more commercial use and areas where there would not be exposed to commercial use. Now, putting this together, in addition to looking at the zoning districts and the areas where this use would be allowed, there also had to be consideration given to the spacing requirements, which are common types of regulations in this type of ordinance. The original ordinance required a 500-foot spacing. In looking at the actual way that laid out on the map, it's problematic whether that could have been upheld under John anyway, because as those existing commercial districts are laid out, there are a very limited number of sites that would meet those spacing requirements. And so in arriving at that 300-foot spacing requirement, my understanding is the Planning Commission took a look at that particular area and recognized that in addition to aiming these uses to that area, it also had to write its ordinance in a way that businesses like this actually could locate in those areas. And Gladys, I think you've taken the time to look at some of the sizes of some of the other commercial areas, and maybe you could walk us through how a larger spacing requirement might work or not work here. That's one of the things that's been suggested, is that the township adopt an ordinance that was modeled on one used in Rango Township down in the Marshall area, which had a 600-foot spacing requirement. In in that particular case, for that particular township, that was upheld by the court. But under the facts there, when that ordinance was applied to that particular township, it allowed about 55% of the commercially zoned land in that township to be used for that type of use. And so we have to be cautious. There's no magic number, no magic percentage, but we have to be cautious that there are a sufficient number of sites that could actually meet those spacing requirements to satisfy the constitutional requirements. So,
in the areas that we looked at, all of the commercial, you see them highlighted in the pink here. You'll notice that this here is the Landers subdivision where the Citgo gas station is. We have the Houghton's LP Gas is the more commercial. This is commercial, but it's also homes in this area. The size is not really deep enough to meet the setbacks on any of the commercial that we would like to keep as far as adult entertainment. When we go south from there, we look at these smaller lots. They're commercial. That is where the auto repair shop is, the restaurants, and through this area, through this section here. Most of these are already used, but there's residential in behind those areas. This is can be considered Rogers Heights in the village area. When you go south of there, you're at the laundromat down on Hayes Road. And then from there south is to Obert Drive is not commercial area. So you're very limited in this area. When you go to this part here, it is the corner on 11 Mile going south to the rental, truck rental to Gallup's Guitar, then Wakes and Trails. Then there's the church owns the area there, right, that park area. So that's the commercial in that district going south.
and if I can just, I don't know if you see this, but this block is about 330 feet deep. Okay, so that really limits the spacing that could be applied in there. And these lots are even shallower than that. So the maximum depth in that area anyway is about 330 feet of depth.
When you start at 205th, where the Dukes area is, there's a small commercial area there, but there's residential all the way around. As you know, 205th does not go all the way through. So we're also looking at traffic coming in from 11 Mile, if that would be a possibility there. When you come south on Northland Drive, there's at Old State, there's the Service Master on the corner there. We have residential in that area south going to 197th and where the small cabins are at 197th Northland Drive. There's a 20-acre parcel there. That would be a possibility the way it was previously to our zoning, as long as it met that setbacks, and that would have been an area at 197th Northland Drive. When you go on the other side of Old State, you'll find that they have the airport, and then south of the east of the airport is also Old State. That's an area that is commercial area, but that's mostly the airport. I think there's ag in there, but it has been designated as commercial years ago. If you go south on Old State, coming further down, you're going to be coming into Old State and 8 Mile. You have the Stanwood Motorsports. When you look at the area there, we have 2 of the motorsports places are now in operation. We also have a place here that's the old Frito-Lay's building. And if you look at the area there, that was another possibility that the previous zoning would have allowed it on the at that area across 131. So that was something that was already allowed in our ordinance where the BP is. So when looking at this, we also had at Ice Mountain, we have the storage buildings and A&A Builders. That would have been a possibility at the storage buildings. And at that intersection, we do have the Big L Lumber and the fire station there. I think when the Planning Commission was looking at these things, they looked at the master plan, and the master plan had this area here as a village commercial residential. So the future use was to have MDR and have more apartment type commercial in this area here, and looking into bringing commercial area into the 8 Mile and 131 area. But we are very limited to the size of our commercial and what it's already being used for.
Any questions or additional comments from the Planning Commission or Township Board on what I understand the thought process was why this particular location is facing requirements for ride?
If I can speak on behalf of the Planning Commission, sitting on that commission also, we're quite limited. Mecosta Township is quite limited as far as the places that it would even be allowed. And I don't know, Gladys, maybe you could tell me on 197th by R&R Cabins, that, I mean, what is the furthest setback that would allow?
Well, in our previous zoning, it would have been within 500 feet of within 500 feet of residential.
So we could have done the 500.
So it would have been with a 20-acre spot on a corner section there. That building could have been removed and had the 20-acre spot for plenty of parking. The cabins, I believe, when we looked at it, would have been far enough away from anything there that would have met the setbacks.
Yeah. And I know at the time as we were going through the process, I reported to the Township Board that it's, you know, it's really limited, although it was previously in commercial zoned for commercial use. It was moved to the highway interchange because pretty much not wanting it on Northland Drive. So where were we going to allow for it? And I know it was discussed several times, so, you know, again and again at every Planning Commission meeting, and that is what we came up with. I don't know if anyone else has any considerations as far as the location.
I was wondering, it seems to me after listening to all the comments and everything, that one of the big concerns is that's the first thing people see as they get off the highway to Stanwood, and, you know, as far as property values and whatnot. So I was wondering, what about that spot by Kane's Airport? Is that doable? As far as, you know, 500 feet away or anything? That would be a little
You have some residential in there.
a little more out of the way.
Okay, I think they're using that for ag now, that area. And maybe correct me if I'm wrong, but I think the Planning Commission looked at some of those areas, and it was considered with traffic and that type of business, having more traffic generated through that area where it's not as well traveled and the road's not as good. That would be something that you know, could very well be looked at. I think one of the things was when we looked at the master plan, and if we can all think back to that point, which was a while back, we looked at one of our first things that we looked at was principal use per parcel, and doing at least two things in the master plan. The second one was deleting the non-commercial usage in our highway interchange. And by deleting to build more into that area for commercial usage. And I think that's when we really started looking at adult business, to take it out of the village area and out to an area to where it would be easier for traffic to get to that type of a business or bigger business, and keep it off of our smaller roads because of the traffic that might be considered there. If we looked at that, that would be probably an area, I'm not sure the acreage on there, but that would probably be the only spot there too. It was more limiting to if we would have to leave it into commercial and branch it out with the commercial on Old State, and not just put that one particular parcel is what we kind of looked at. We were singling out one particular parcel or two parcels instead of making it enough broad area. So if one of the other planning commission can relate some of that, it's been a while back since we really looked at that.
Well, and the choice isn't to allow for it or to not to allow for it. It's what is a feasible place to allow for that, and recognizing that, you know, the public clearly says they don't want it anywhere. You know, the state of Michigan says that we do need to allow for this, and that was what we came up with. You know, I don't know if the choices are very, very few. We do need to allow for it. What does that mean for Mecosta Township? The Planning Commission considered it very carefully.
I'd like to also add that the Planning Commission did meet with the Township Board a couple of times. We did discuss it. And I think that the board also felt, in looking at it, what we were trying to do, the board agreed with what the Planning Commission had come up with. And to try to get it away from most of the residential and still have a place that they could legally come into the township and do it if somebody applied.
Do we know how many acres we've got in commercial?
I've not added up all the acreage. I haven't.
Just for curiosity, I mean, of this packet that I've read, which it's overwhelming, but there was something in there that there's no magic number for how much of your commercial would fit the category, and the example was as little as 5%, but there's no magic number. So I guess my question is, if there's 100 acres of commercial there, and 20 of it is available, whether it just be one parcel of 20, that's 20% available, right?
Well, I wouldn't say it would be 20%, it's far less than that.
You got 16 sections at about what?
Right, but as an example, I mean.
Oh, you mean just the commercial?
As a percentage
Just
of the commercial.
Right,
Okay.
because, unless I've read it wrong in here, but what I've looked at in here is that in, I don't know what township it was, but they come out and they were, 58% of it was
Commercial.
suitable for that.
Correct.
But you only had X amount of acres of it, and so I mean, it wasn't like there's 58% of the township was,
No, 58% of the commercially
Commercial, right.
zoned.
right,
So it would fit into 58%. So to put a setback, like for example, in Marengo Township of 1,000 feet, 600, I don't know, it was allowable in other areas. So it's not that it eliminated it, but it
right.
had to move to a different area that had at least a 600-foot setback.
But I guess my question is, we look here and say, well, this place may fit, you know, the old setback, you know, you got 2 or 3 locations there. Of that, what is the percentage of that versus what the total commercial acreage is? I mean, is there a fair percentage there? I don't know, I'm just asking.
But does it really matter?
Well, according to what I read in the law, that you've got to provide a place.
Yeah, and we are
Right.
trying to provide a place.
Correct.
Percentage-wise, I'm not really sure if that's relevant to the overall.
But it said it's
Yeah.
questionable whether, yeah, it's kind of how that judge or
Yeah.
whoever would rule if that was the case.
And that's why the setback is 300 feet. Where else can we put it? Commercial or highway interchange that was anywhere reasonable to any other property.
And I think that's one of the
homeowners.
things that we visited when we spent the money on the planner to go through the master plan. And that's, I think we need to make a broad distinction between what the zoning map is now and what the master plan is. Just because we worked and put together this future land use map, that's exactly what that is. That's a future land use.
Right.
And so I don't want us to get confused, but I think that also our planner looked at the spacing, and that is why we, in our future land use map anyway, that's why we put it where we put it.
Actually, somewhere in there, we do have a thing about how much commercial we get.
I was looking at the Marengo Township, and they got a 600-foot buffer.
Yeah, that's correct.
That may have been.
And how many, whether that allows a reasonable number of sites that would satisfy the constitutional requirements depends, you know, very much on how that particular township's zoning districts are laid out.
Are they similar? Seems like I read that they were similar in size to Mecosta Township. They're a smaller township.
I think they are similar in size,
Yeah.
which doesn't necessarily mean they have the same percentage of commercial that you do or it's laid out the same way. You know, the suggestion to have a 600-foot spacing requirement at that particular location would probably disqualify much of the land that's been designated for that area.
Most of the distance they can be off the road.
It wasn't a setback from the road, it was a
I know,
setback.
but I thought they couldn't be so far back from the
I think it's 400 feet
It can't be.
depth.
more than that, right?
Yeah.
So that eliminates part of that for the marina and the power sports, because that's more than 400 feet right there.
Well, and I think what
So-
helps is the master plan map that we did, and that's what we were looking at when we did this. The village commercial, which is in Rogers Heights and that, so if we look at that as village commercial and what it basically states on having that kind of commercial, it would eliminate, as you said, the percentage of the commercial. That would take that part out because it's basically stated for more of a little grocery stores, mom and pop shops. Right behind that area, we're looking to have more future uses for apartments, more multi-housing type projects. So if we eliminate that whole section, as you can see there in Rogers Heights, we're then going into the area right at Old State in 8 Mile and 131. So it could be something that if to increase that area, but to put it in another area or look at it in another area towards Rogers Heights, it's defeating what we've already done in our master plan. We did increase the commercial on the other side of Old State, I believe it is, in our future use. So that would allow a little bit more commercial area in that area.
Enlarging the spacing requirements for some of these properties only paints you further into a corner in some ways. I mean, make it a 1,000-foot spacing requirement if you want, but ultimately there still has to be accommodation for this, and you can make it 500 if it feels better, or 600 or whatever, but then it's just that much more difficult to actually find a location in the township that meets legal requirements. It's a tough call.
Well, if there's no other discussion about location and spacing at this time, I can move on to a couple of the other types of ordinance provisions that you have in your ordinance. And we can talk about whether those should be reconsidered or changed in some way. Now, your ordinance does not allow total nudity. Performers have to appear wearing essentially G-strings and pasties. They have to be on a 18-inch high stage in a room that exceeds 600 square feet in area, surrounded by a railing separating them from patrons. There are also prohibitions against prolonged contact between patrons and entertainers. Now that is a type of regulatory ordinance that is found in the Moratorium Township ordinance that was given to you. That's similar to what the city of Grand Rapids has, similar to what Big Rapids Township has. It's a common type of provision that cities, villages, townships adopt to try to regulate some of the secondary effects of this type of business, prevention of prostitution, unlawful sexual activities, that sort of thing. Overall, comparing your ordinance to some of the other ordinances that have been given to you to look at, like Moratorium Township, City of Grand Rapids, Big Rapids Township, New Buffalo. I think there's one other ordinance that has been given to you. Your ordinance contains already most of the regulatory types of provisions that those other ordinances have, and is in most cases as stringent as the courts have allowed municipalities to be with this type of a business. So as far as the extent of nudity prohibited or allowed in these types of businesses, looking it over, your ordinance goes about as far as it legally can go with regard to that. Again, it doesn't allow total nudity, and it requires performers to be on a stage and separated from patrons. And I know there was some discussion coming up and looking at those rules, but in fact, I think that part of the ordinance probably goes about as far as it can go. Any discussion or questions about that particular point?
Does the, if they were to serve alcohol and have a license through the state, is the amount of nudity governed by the license?
The state law prohibits total nudity in licensed establishments, although that particular part of the law has been challenged and struck down. It does also require that there be a topless activity permit issued by the state, and that has to be that would only be issued if the township approves that type of license resolution, which hasn't been done at this point. So they would call that topless activity permit, and that would be a permit they would have to have in addition to their other on-premises license.
And who enforces that?
Well, if they were totally nude, then that would be a violation of their liquor license. That would also be a violation of the zoning ordinance as it was written.
Our ordinance reads that an applicant owner shall permit all representatives of the township, Mecosta County, and the state of Michigan to inspect the premises.
So as far as the liquor control goes, I think that's probably enforced by the state police, or the liquor control has its own investigators that would enforce that.
Can the township limit the amount of time that they can serve?
The township cannot limit the amount of time that they can serve alcohol. What it could do, I think, is it could limit the hours of entertainment in the establishment. Currently, your ordinance allows operation between 10 a.m. and 2 a.m. Other ordinances have been drafted, have been upheld, that have a closing time or at least an end time for the entertainment of midnight or 10 o'clock. You know, some of the rationales that I've seen in some of the materials for those, and you know, I take them for what they are, is that you know, there's concern that the combination of nudity, semi-nudity, and alcohol tends to have a exacerbating effect on the way people behave, and that having an earlier closing time than other bars might be of assistance to law enforcement. Currently, your ordinance does limit the hours of operation from 10 a.m. to 2 a.m.
Doesn't it seem odd to have it open at 10 a.m.?
Thank you.
And it means that, yeah, they have the opportunity to be open at 10.
Whether they open at 10 a.m.
Right.
you know.
Some people work the night shift.
Do you know, Jim, I've been told, and I don't know if it's true, but the state of Michigan allows, if there's no alcohol served, that they can have total nudity?
There would not be a state law against total nudity if there's no alcohol served on the premises.
Okay. We do have a nudity ordinance, so for our
That's
sake.
correct. Most communities have an ordinance that prohibits total nudity anyway, and you do have one. That is a municipality by municipality decision. Another feature of your ordinance is that it does not prohibit alcohol consumption if the establishment has the appropriate MLCC licensing. Communities take different approaches to that. City of Grand Rapids, Big Rapids Township, New Buffalo ordinances that we took a look at, they do not prohibit alcohol sales in this establishment. The Marengo Township ordinance that was given to you does prohibit alcohol consumption, and that is a restriction that's been upheld by the courts. And so that is something that.
So that's a possibility that we could prohibit alcohol sales.
Generally speaking, the prohibition against alcohol has been upheld by the courts. Other regulations in your ordinance, again, they're just very similar or identical to provisions in the Mecosta Township Ordinance or other types of ordinances like this. Minimum levels of lighting for exterior and interior areas, limitations on signage, prohibitions against being able to view the activities from outside the building, requirement for a manager station where all the areas in the building can be observed, background checks of owners, prohibitions against prolonged physical contact between patrons and entertainers. Overall, your ordinance follows very closely ordinances adopted by most communities to regulate this type of business in terms of the types of regulations and the operations of the business, the hours of operation, the requirement of a stage, the prohibition against contact, the lighting regulations, the manager station, the background checks. Most of those things in your ordinance are very, very similar to whatever in other ordinances and would have been upheld by the courts as reasonable time, manner, and place restrictions on this type of operation. Some regulations that are included in other ordinances that are not in your ordinance. Some communities have a much more comprehensive system of licensing for this business, in addition to regulating the location, the layout, and so forth. They require licensing not only of the owners, they also require licensing of the entertainers, which primarily consists of ensuring that they're 18 years of age or older and that they haven't been convicted of certain types of crimes involving prostitution or lewd behavior or other types of crimes that would disqualify them from getting a license. And some ordinances have requirements for regular patrolling by security personnel of outdoor areas, which is probably something that could be imposed by a business like this, even if it's not explicitly in the ordinance. So, any questions about those provisions? A discussion about certain provisions that the township might want to take another look at, consider how they may want to address those things.
So I just want to get this right. If they couldn't serve alcohol, they couldn't be fully new.
It could be.
It could be.
It would be.
But I thought we had an ordinance about nudity.
We do, but I said state law.
Okay.
Yeah, state law override us.
State law, my understanding is if there is no alcohol, they can be 100% nude. If they serve alcohol, I believe they have to have at least bottoms and
Oh, right.
Your ordinance would not permit total nudity whether alcohol is served or not.
So the state ordinance wouldn't override our ordinance?
That's correct. The state doesn't have a prohibition against total nudity in private places of business, unless there is alcohol being served there. But your local ordinance prohibits total nudity, and your
we also have a nudity ordinance the township board had passed from back in '96, and I believe it was updated also.
that's correct. Does anyone want to go through point by point and talk further about some of these areas? Anybody?
Jim, I just wondered if you would have some sample language or boilerplate language from some of these areas that do license their entertainers. Do you have any sort of information you can send along to us?
Yeah, the Moratorium Township Ordinance, for example, does that. And that would be done as a separate ordinance, a so-called regulatory ordinance. For many communities, these types of businesses were established before they started enacting comprehensive regulations on it. So, and that's one of the reasons that regulating some of the behavior of some of the licensing of entertainers, owners, is done by a regulatory ordinance. It's not part of the zoning ordinance. And an ordinance regulating entertainers, requiring licenses of entertainers would be a regulatory ordinance and not part of the zoning ordinance.
Thank you.
I have another question. Since we are such a small community here, and to open an establishment like that, would the business need to have a market demand study done before they invested in a place?
They would not. The extent of demand can be a factor taken into account in determining whether there are a reasonable number of sites made available in a township.
I'm talking about, I wonder if they would have enough people come into a place like this to be able to stay open.
That would be part of their business planning, part of their business model.
So it would be part of their business plan.
And in terms of regulation, where that could come into play is in determining whether there are sufficient sites available in the township. And in this case, without doing a market study, I think just from observation, you'd probably say there hasn't been a huge demand for this type of a use. And so, I don't think you meet the 58% requirement that Marengo Township met, but because there hasn't been much of a demand, you may not be subject to such a high standard.
Jim, could you discuss briefly the prohibiting alcohol sales? Would that be, I know we discussed before, like a regulatory ordinance also, and what that would mean, what it would look like?
That could be in the form of a separate regulatory ordinance that would be a regulation on liquor sales. It would not have to be part of the zoning ordinance. That would probably be the recommended course of action to address it if that's something that the township wanted to do. The other option is the township does have to approve the transfer of the license and does have to approve the topless activity permit, and can decide whether or not to do that. It would be, I think, more defensible if the township had adopted the policy in the form of an ordinance with respect to that.
So those are done at the township level. Is that correct? I just wanted the township.
That would be done by the
understand
township
that.
And what your ordinance now doesn't expressly permit alcohol sales in these establishments. It allows them if it's pursuant to a license issued by the state of Michigan, and part of that licensing process is getting local approval.
Now, they need a copy of our ordinance that either says yes or no to the liquor, right?
A resolution, that's correct. Well, just to review some of the options that the township has available to it. Right now, consideration of site plans and special land uses in the commercial districts has been suspended to allow the township to consider whether changes should be made to its ordinance based on the information it's received and studied the ordinances from other townships. The township could continue that suspension and could continue to study and discuss whether some changes ought to be made to the ordinance, the items we've talked about tonight. It could terminate the suspension, and in which case the Gentleman 131 application would go to the Planning Commission to be reviewed in accordance with the standards that are in the ordinance. The township could now or in the future also adopt additional regulatory ordinances that might address issues such as approval of liquor licenses for sexually oriented businesses that might put into place more stringent provisions for renewal of licenses for establishments, requiring continued background checks of owners. It could include provisions for licensing of entertainers. could include a review of the historical operation of the business to determine if it's if it's been in violation of its approval, to determine if there have been a undue amount of police calls or problems with the facility. And so those are the basic options open to the township. And I think we're hopeful that tonight we can get at least some direction on how the township wants to proceed.
I would like to just briefly discuss location. I can't see it in commercial. I know we discussed that at the Planning Commission, and I still don't see it on Northland Drive or anywhere else. That's my opinion.
I think that's about the only place it can be in the township. There's just not enough space anyplace else, and it's just not feasible. We spent a lot of time, I think we had 3 meetings just over where we were going to put something like that. And we did do quite a bit of research on it, as much as we could.
And we hired a planner to help us.
So Tim Johnson was there, helped it every step of the way.
Well, the main goal was to keep it away from all the residents.
Or as many as possible.
Exactly.
It's hard to keep it away from everybody, but it has to go somewhere.
Exactly. And the only logical place, if I remember correctly, would be on the other side of the expressway by the old Frito-Lay. If you went to 600 feet, that'd be about the only feasible place.
It would be in the same area, same general area, it would just be on the other side of the road. Is that really doing anything?
Well, it does get away from a couple houses, so.
That's right.
If I may interject, I think that whole area was looking to be highway interchange though. So it's not only that Ruddy Ducks being highway interchange, but also continuing it towards Ice Mountain, and then across the road is going to be highway interchange. So if you increase it in highway interchange, you're not going to have as much residential. I think that's what they were looking at when they did the master plan, wasn't it?
Mm-hmm.
To be more commercial friendly.
Well, we extended that industrial zone where
Yeah.
Ice Mountain was.
Yes.
Across the road, or is, sorry, across the road, and then all the way up to across the street from Ruddy Ducks.
Yeah, highway interchange is straight across the road.
And it's not deep enough on the west side of the freeway. I mean, how deep is that? About 400 feet in there?
It is what it says.
Yeah.
That's what we
Yeah.
did the ordinance.
Yeah, I mean, there's just not enough room to put anything commercial. Because right next to the Frito-Lay land, that's all zoned ag.
No, that's commercial.
I own that parcel.
You mean the part behind it?
Yeah.
Yeah, the part
Behind it.
behind it there, yeah, behind it. Yeah.
And I believe one of the other things that we discussed at the joint meeting is part of why we're trying to move the commercial out there that is Highway M20
Right.
from the west. So there is a fair amount of traffic out there that would come in there and turn and go to the north. And if that's going to be your state highway that's coming through the township, that was basically where we figured we would rather expand our commercial. We really didn't have many other spots.
So again, these are points of consideration. I don't know if you want to do anything tonight.
I mean, not,
Discussing.
it's my understanding that it's up to the township board either way we go, correct? I mean, planning commission really can't do anything at this point.
Right.
That's correct.
Right, so the input that
Right.
how we came to the ordinance, we need that input.
So basically, we could do an ordinance to stop the liquor sale.
That's something you could consider.
Pardon?
That's something you could consider as a separate regulatory ordinance.
Put the cart in front first.
As to what?
Liquor. We have to go to the step here.
You gotta speak up, Jen. Okay.
I think we need to go to the next step here, and as far as the liquor issue, that's something the township board can decide. We've got the zoning here, we need to go to and proceed. Are we gonna go ahead with this or what?
I really don't understand what you're trying to say. I'm sorry.
Well, Rick, President, we got a moratorium on everything, and we've heard everything. I don't know where else we're gonna go. I don't know what, we've looked at everything. The zoning department has done a great job, the board. I mean, we've looked at this, and looked at this, and looked at this. And I know there's opposition, that people don't want it at all. However, by law, we have to make a place for it.
Well, I'm not saying not make a place for it. They be at Ruddy Ducks but, do an ordinance to stop the liquor sale.
And that would be done at the township board of trustees level. Or, that doesn't necessarily have to wait for a township board meeting. Is that what you're saying?
Or we can do this before we lift the moratorium, right?
You could do that. You could lift the moratorium and consider that separately. You haven't reached the point where you have to make a decision on the license.
Okay.
That's what I meant by the cart in front of the horse.
If we did do that, if we went ahead and then we all discussed the liquor sale, and if the majority of us decided we didn't want to have a license for liquor.
But it's not up to us.
All right, I'm just saying, if the board heard our opinion, and then the board goes and makes a decision, do you consider what the community and what the planning commission want when you make that decision?
I always
Yes.
consider that.
Yes.
Okay,
I always consider that, yes, absolutely.
all right,
And I think
Well-
that's why, I had the thought.
yes.
Wasn't that option presented to the planning commission before they brought it to the board?
You mean no liquor?
No liquor? No, not really.
No.
All of the sample ordinances that we had did not have that in there. Is it something that we thought about? I didn't. It was never discussed, and as ridiculous as that may sound to anyone, it was not discussed. I didn't think that it was an option.
I don't know if you realize.
Did we ask?
I don't
And it
think
might
we knew
sound
it was an
ridiculous.
Yeah, when we start reviewing this stuff, I'm not kidding, we probably have 600-700 pages to read before a meeting. And it's great material to go to sleep to, because it's a lot of material to comprehend all at once, and for all of us to get every single point in there, it's almost impossible. And, unfortunately, we didn't think of that one. We just...
Well, and I'm not certain, had that come before the township board, I don't know what I don't know what would have happened
at all.
at that point anyway.
Place used to have a liquor license.
It
I
did.
mean, I just assumed it was
Right.
gonna go along, okay?
But now, does a liquor license from Ruddy Ducks, is that with the owner, or does that go back into the pool in the county? Aren't there only so many liquor licenses allowed in a county?
I assume the Ruddy Ducks license was placed in escrow.
Okay.
If you want to ask specifically, the folks are here and they can tell you that. But I assume it was placed in escrow and still owned by
Whoever owns it.
I believe that's the case because we've already gotten application for us to vote on from the state of Michigan to transfer the ownership. So therefore, there already is a liquor license for that facility and has been for years.
So it's available.
It is available. Do we have any other input?
So even though it's available, we still have to approve it, or the board has to approve it, correct? They have to approve that it can be sold.
That's what Jim has here. I don't know because there's two licenses that they've applied for. And the one that says right on it that the state does not have to go by what the township says.
That'd be something to find
So-
out for sure.
Well, they've asked for approval to transfer the on-premises license, which requires township approval. They've asked for a topless activity permit, which requires township approval. They've also asked for a off-premises sale, which I would definitely require township approval.
As for, I'm sorry, I didn't hear what you just said.
Off-premises sales,
What is that?
Yeah, what is that?
carry out.
Carry out. They can buy a six-pack and take it with them or whatever. And I believe that one on the, I think that's the one on the state form says it does not require our approval for the state to allow it. That's up to the state.
So that if they have a liquor license, they can just do it.
If the state approves it. There's two different licenses, but the one, we have no say on it. They want our input, but we basically have no say on it. As it says so right in there that they can make a decision on that without us. The only thing we did is contact them and said at this time that wasn't zoned for that, and we were not going to vote on it until
Does the package,
this is ever done.
does the package liquor application stand alone, or does that have to be in combination with?
I don't know the answer. I think it can stand alone.
I believe it stands alone only because we got them at two different times and two different dates from the Control Commission.
Okay.
So does that mean that if a regulatory ordinance was passed by the Township Board of Trustees, they could still have a
Off-premise.
Yeah, off-premise license?
You could have them all out drinking in their car.
Right. I mean, I mean, they
Well, that's
can have
possible
one, but
anyway.
not the other.
Exactly.
If
No alcohol.
if we pass no alcohol, what's to stop them from going outside and having a couple of drinks and come back in? I mean,
Well, I think the spirit of the moratorium, this is exactly why we placed it. As a member of the Planning Commission, as a member of the committee that looked into our master plan, and I mean, these are things that hit home runs in my head that, you know, this information wasn't made available to us by the planner. It wasn't available, as Mary had mentioned, in any of the sample ordinances or sample master plans we've got. And so, in the spirit of the moratorium, I think this is a great opportunity to, you know, look at something that we did miss, legitimately. I mean, this isn't just
Or, well, yeah, a point to consider. It's like, you know, it is a point of consideration.
right. Because I guess as a 18 months ago or 24 months ago, going through the master plan or even going to the, most recently, the zoning ordinance, I would have grave concerns as a planning commission member of the alcohol business or the package sale as to how that would affect, I mean, there's nothing to stop people from stopping at the BP station to buy a six-pack of beer and go out and drinking in their car, but doesn't make it right because
Other than you'll have law enforcement there
Right.
to take care of that, we hope.
You also have law enforcement at the Copper Top, the Eagles,
Right.
every place. You know, this is gonna be a standalone
Right. Well, the
deal.
difference, I would hope that at the Eagles, you're not out in a vehicle drinking a six-pack, you're inside.
You can't.
No different than the Copper Top.
That's right.
You can go to a party store and go do that.
Yeah.
Right.
You go to the Copper Top party store and get your six-pack right there.
But as I guess as a, from a planning situation, as I looked at the zoning plan for this particular use, it would concern me to combine those, a packaged liquor sale and an
Right.
adult business on the same location. That would have been a red flag had it been brought up
Right.
by
That
the
was-
planner or whoever.
Never thought of, never,
I mean, I know if I thought of it, we would have definitely talked about it, and probably I wouldn't have wanted it in there. I mean, I wouldn't allow it. I don't know how everyone else feels, but
What wouldn't you allow?
alcohol.
Alcohol?
Inside sales or carry out?
either.
I would definitely not have the inside sales. I don't think we can prohibit the carryout from what you were saying. I don't think, since it's two different licenses, I don't know.
I don't think they can.
I don't think we can do anything about the
I don't believe
carryout.
they can get the carry out if we don't approve alcohol. We got the alcohol application first. About a month later, we got one for carry out.
Okay.
So based on that, the alcohol one we got first, the board has to approve. The carry out one, they asked us to vote on it, but it says right on there that we don't have to do it, and if we don't answer within 15 days, it doesn't matter, they don't have to take our vote. And the only thing I did is I had the attorney make sure to contact the liquor commission. At the time we got them, so they knew the status of where we were at with the project. And until it is approved under zoning, if it should be approved, then the board would look at it to pass. Otherwise, we are not voting on it. There's no reason to transfer a liquor license if the project isn't going forward. And most likely, the current owners wouldn't give up the liquor license if it wasn't approved, because it doesn't do anybody any good, then it's just out in limbo someplace.
So, I guess if I'm back to the same question, can we adopt the resolution of non-approval for liquor?
You could do that. Again, it might be preferable to do that in the form of having an ordinance in the township that you won't approve liquor licenses in connection with businesses that have topless entertainment, as other communities have done.
Would this be the time to do it, or do we have to drop the I can't say it.
The moratorium.
Moratorium.
You could adopt it at any time. It's a separate process from the zoning approval process.
That'd be an ordinance that you would prepare for us, correct?
We could prepare an ordinance for the township board to consider. And you could decide whether or not to adopt that. Your decision may adopt or not adopt a resolution approving the transfer of liquor license and the topless permit.
Do we have to vote on that then? And
You would eventually have to vote on it, yes.
oh, eventually, not tonight then.
Well, we wouldn't
You'd
have to do it.
prepare it and then bring it to the board.
That could be done, yes.
So do we have to vote on that, if we want you to do that? Or make a motion?
We don't do anything.
Okay.
Well, I think if I get the sense of the meeting, really the locational issues, you're fairly satisfied that you've done what you can do with those. The hours of operation, the internal layout, those sorts of requirements you're fairly satisfied with.
Can I say something?
And the one issue is the liquor.
The hours of operation, the ordinance, I mean, if that was, I don't know what everyone thinks of that. If that was limited, what would that be in the zoning, or is that a separate ordinance at the township level also?
Well, because that could be a separate ordinance in the township. And if you were to do that, then, it would be advisable to have the planning commission amend the zoning ordinance to be consistent with it.
from the reading that we've done, there are a few townships that have done that, that have had it open only till midnight.
That's correct.
I would be in favor of that. Shorten the hours. And to have something drawn up where no alcohol.
So would I make a motion then to limit the hours and then no alcohol and have you,
Well, I mean, if the consensus of the board is that you'd like us to pursue that and leave the moratorium in place
until we get this done?
until you have a chance to consider it, then you could do that.
Now, if by chance the township board decided to let the planning commission go on and lift the moratorium, and we go back into our process, can the township board still work on an ordinance for the alcohol at the same time? So we're not going till next January on this.
You certainly want to get things done properly. I believe the township board could lift the moratorium, and the township board could at the same time consider whether it wants to prohibit liquor licenses and establishments that have topless activity.